just give me a brief overview of the proposed amendment, such as where it is coming from, and I mean, what sort of changes are being suggested?
Okay, Simone, I think it's good to give a bit of background on where the mining tax regime comes from. So the business of mining is unique compared to many other industries in at least two ways. Firstly, the amount of substantial costs that you need to incur to create a mine. It's staggering the amounts that needs to be spent even on a small mine. Something like an open cast coal mine is expensive to develop. And so the one unique element of mining is the cost. And the other element is that typically there's some time delay between when you start spending the money and developing the mine up to the point where you can start producing and earn income. And those delays can be very long and very substantial in the case of larger mines. And of course, in between that point of spending money and earning money, there are various variables, including the commodity price fluctuations, mining being as cyclical as it is, and geological surprises as you are developing a mine. And just to remind ourselves that the mining life cycle typically has 4 distinct phases. The first being the exploration phase, the second being the development phase, where the real money is spent on the capital expenditure, typically sinking shafts and related infrastructure. Then you get to the point where hopefully you start making money, which is the production phase. And then lastly, you've got the closure phase or the rehabilitation phase. So that makes mining quite unique. And the mining tax legislation acknowledges that uniqueness and the fact that some incentive is necessary from a tax perspective to get industry to invest in mining and to stay invested in the different life cycles of mining. And for that reason, the Income Tax Act of South Africa gives certain incentives to investors in mining. For example, at the exploration phase, there are certain incentives. At the development phase, there are incentives, which we'll talk about more today, as well as to encourage you to set money aside for that closure rehabilitation phase. And then if you're a gold miner, if you thought mining is special, the really special child in the room is always the gold miners, because of the history in South Africa with gold mining, the amount of jobs created in gold mining, etc. So then there are some additional special treatments for gold miners. But what's happened is South Africa's mining industry, of course, well over 100 years in existence. But the last 25 years or so, there's been some interesting developments and changes in the mining industry. In my view, very positive changes, in the sense that smaller players in the mining industry have been able to meaningfully participate in the industry. And as a result, because of capacity constraints, risk profiles, etc., what's happened is typically the smaller players, and I think everyone participates in this today, have opted for the contract mining model, wherein the mining right holder does not need to spend all the money on buying the mining equipment, etc. Instead, what they would do is they would share the risk with a contract miner, being an independent contractor that own their own plant and equipment. And the independent contract miner will be appointed by the mining right holder to extract the minerals on behalf of the mining right holder for a service fee. And I think for most of us today, it feels extremely normal, but the mining industry has not always been like that. That's really been a development over the last 25 years or so. And that has brought about certain complex questions, in the sense that we know that because of the unique risk profile of the mining industry, tax legislation gives special treatment to miners as a class privilege. But the mining tax legislation could not have foreseen this development of independent contractors that render a service to a mining right holder for a fee. An independent contractor that does not own and sell the mineral, if I can put it that way. Of course, no one actually owns the mineral except for the state, but legally the one who extracts it and then sells the mineral, and then and also then earns income from the sale of minerals and the actual risks of mining, the commodity fluctuations, etc. Now you've got a contract miner that really just earns income for rendering a service. And the question has arisen over the years, well, should that contract miner also qualify for this class privilege, for the special tax treatment? Now, perhaps I should just pause for a moment and explain what is this capital expenditure allowance, this benefit that you get if you're a mining operation, or if you're involved or engaged in mining as defined in Section 1 of the Income Tax Act. Now, if you qualify for mining as defined, then essentially you get the benefit of an upfront capital expenditure allowance against your income that you generate from mining. To put that into context, Simone, your average taxpayer generally, if they spend money on a capital plant or equipment, do not get an upfront allowance, in the sense that you can deduct that amount that you've just spent on a capital good from your income to reduce your taxes payable for the year. How it typically works, so that the Income Tax Act says you are not allowed to deduct it in year one, and depending on the industry that you're in, but for example, let's take manufacturing as an example, you get to deduct that 100 Rand, for example, that you've spent over 4 to 5 years against your income for tax purposes. So generally, there are allowances available for taxpayers against money spent on capital plant and equipment that qualifies. However, it's typically spread over a period of time. For mining, the special treatment comes in that you are allowed to deduct the full 100 Rand in year one that you spend it. But the deduction is limited to income that you have earned from mining. So essentially, this benefit that you get as a mining company is ring-fenced to income from mining on a producing mine. And then there's one additional ring fence, and that is that the income or the capital expenditure that you spend on a particular mine is ring fenced against income earned from that mine. So there's a general mining ring fence, and then there's also a per mine capex ring fence. But like I've explained, the benefit is if you have a mine that's really producing significant income, then you've got the opportunity of reducing the taxes payable in the initial years of your mining operation, because you get this upfront deduction. Now, the general view in the industry, Simone, has been that an independent contract miner does qualify as mining or mining operations as defined in Section 1. And that is due to the definition in Section 1 of the Income Tax Act, which, paraphrasing slightly, is essentially this: every method of mining is defined as every method or process by which a mineral is extracted from the soil. There's no requirement to be a mining right holder currently, as the law reads. And so the argument has gone that because there's no requirement to be a mining right holder or to share in the risks of a traditional mining model, the argument has gone that an independent contract miner service provider also qualifies for these accelerated capex allowances. The Supreme Court of Appeal last year, in the year 2019, delivered a landmark judgment in which the court confirmed this view that a contract miner does qualify as mining and mining operations as defined in the Income Tax Act. So essentially, the Supreme Court of Appeal confirmed the industry view and the way that many contract miners have been treating it. But a minority, one of the judges also commented that he's of the view that it was indeed not the intention of the legislation to do it. It is what it is how it reads, but he would make a recommendation to National Treasury to consider amending the legislation to close this opportunity for a contract miner as opposed to a mining right holder. And that is indeed what has happened. So in February of this year, February 2020, there was the annual budget review, in which the Minister of Finance announced that they are looking into this, what constitutes mining, and that they are concerned that both the mining right holder as well as the contract miner can currently claim the mining capex allowance, and essentially they will look at fixing this. What then happened as part of the annual legislative amendment cycle is that National Treasury and SARS published on the 31st of July 2020, they published the draft taxation laws amendment bill for comment by 31 August 2020. So there's 1 month to provide comments. And essentially this proposal to amend the legislation has come through. So that's just some background. You can tell me if you'd like me to proceed in explaining what the proposal looks like.
Yes, please, if you wouldn't mind.
Okay, so it's quite simple what they've done, focusing on this proposed amendment to ensure that the allowance only applies to mining right holders. So what they've done is the relevant provisions in the Income Tax Act. I've already alluded to the very important definition in Section 1, which defines mining. Then the actual allowance you find in Section 15 of the Income Tax Act. Section 15, you get an allowance pursuant to Section 36. So you need to read Section 15 with Section 36 of the Income Tax Act. Now, Section 15, essentially in Section 15, subsection A, so 15A, deals with the capital expenditure allowance for mining, and 15B deals with exploration or prospecting activities. So what's happened is in the preamble of Section 15, and bearing in mind Section 15 actually deals with the development expenditure for mining as well as exploration. But in the preamble, they have now inserted that that the allowance under Section 15 or the deduction is limited to a mining right holder as defined in Section 1 of the MPRDA. So you need to be the holder of a mining right as defined in Section 1 of the MPRDA. Paraphrasing again for purposes of our discussion. And by having amended or proposed the amendment in that fashion, I believe that they will succeed in excluding a contract miner, which typically that is not required under the MPRDA to be a mining right holder. So they have succeeded in that regard. And I would say that it's not much of a surprise to contract mining to contract miners that this amendment has come through. We've certainly at Renmere kept our contract mining clients abreast of these developments following the Benhouse Mining Supreme Court of Appeal judgment in 2020. But yes, so that's come about, but we are concerned that the manner in which the amendment is proposed will have certain far-reaching unintended consequences in the industry.
Talking about the unintended consequences, I mean, could you maybe just speak to me on these unintended consequences? I mean, and what sort of additional requirements will this actually impose on people in order to qualify for this privileged mining capex allowance?
The only real additional requirement is that you need to be the holder of a mining right, as defined in Section 1. So how it's worked to date, just to recap, is that you had to qualify as mining, your operations had to qualify as mining operations, which is that generally broad definition that's traditionally included contract miners. You had to then earn income from mining, and then you had to incur capital expenditure as defined in Section 3611 of the Income Tax Act. And to date, a contract miner, like a mining right holder, have been able to, in most instances, tick all three boxes and therefore qualify for the accelerated capex allowance. So what they've done now is they've said, in addition to those three requirements, or the proposal is, in addition to those three requirements, the company also needs to be the holder of a mining right, as defined in Section 1. Now, just focusing on a contract miner, because as I've mentioned, it's not a surprise. They've, the Supreme Court of Appeal alluded to this proposal to correct the legislation. The 2020 budget review indicated they were looking at it, so it's come through. But the way in which it's being proposed presents a challenge, as it reads at the moment, the proposed amendment for a contract miner. You see, if a contract miner cannot qualify for a mining capex allowance, then in principle, the contract miner arguably would qualify for the manufacturing allowance that I've alluded to earlier, which you find in Section 12, Cap C of the Income Tax Act. And that essentially gives you an allowance over 4 to 5 years, depending whether it's new plant and equipment or second-hand plant and equipment. The one challenge that the contract miners face is that currently Section 12 Cap C excludes plant use for the trade of mining. And the definition of mining has not been amended. So essentially the definition of mining would still include a contract miner. And therefore, the way that the legislation currently reads, or the proposals currently read, a contract miner would arguably not qualify for the mining capex allowance, nor would they qualify for a manufacturing allowance. So that is certainly something that we will give comment on, the National Treasury, and point out that needs to be resolved. We believe that's not a problem, and it's just an oversight, a technical oversight, and it should be easy to resolve. So that's the one unintended consequence that is a technical oversight and should be capable of being resolved. Then looking apart from the contract miners and looking more to the mining companies that mine for themselves, mine for themselves and are not rendering a service in the mining industry. Some of those mining companies, due to technicalities of the Mineral and Petroleum Resources Development Act, the MPRDA, some are not required to hold a mining right. So then you've got a company that is not rendering a service, it's mining for its own right in one way or another, but due to technicalities, it may not be required to hold a mining right. And we are aware of certain taxpayers like that. So the challenge that they will face if it is enacted as proposed, the amendments, is that they will also be excluded from the mining capex allowance. Then you get what typically happens in a mining group restructure is you can have a group purchased the shares in a new mining company, and for various commercial reasons, the group, once they've purchased this company, they will decide to transfer the mining business in this old mining company that it purchased. It prefers to transfer that entire business to a new mining company, and essentially to deregister the old company that they've purchased from a third party. Now, in so doing, you need to apply to the Department of Mineral Resources and Energy under the MPRDA Section 11 for the transfer of the mining right. And that, as many taxpayers know, can take a fair amount of time to come through. In many instances, it can take many years to come through. So you can have, in that instance, you can have the new mining company that qualifies as mining under the Section 1 definition in the Income Tax Act, that for all intents and purposes is mining for its own right, and the only delay is really in the administrative transfer of that mining right from old mining company to new mining company under the MPRDA. Now, the new mining company in that instance, if the amendments are promulgated as proposed with effect from 1 January 2021, would, for example, also be excluded from claiming the capex allowance, which is a consequence that we're of the view is probably not foreseen in the initial proposal. Maybe just one other comment is certain joint ventures in the mining industry are run in an unincorporated fashion. So it's not an incorporated joint venture, but unincorporated, where the mining right and the assets are pooled and shared. And in that instance as well, you would understand that only one of the partners typically would be the mining right holder legally. So that would also need to be looked at. What about the capital expenditure incurred by the other JV partners that are not the mining right holders? So there are various complexities that we are currently discussing with our clients at Renmere. And we certainly do intend, once we've gotten all the inputs from our clients, to also make proposals on changes to the currently proposed amendments before the promulgation thereof.
We did touch on it briefly so far, but the question itself just says, could you provide some background or context as to how miners and contract miners have been receiving the special or privileged tax treatment to date, and how this is likely to change going forward? Is there anything that you would want to maybe just specifically attach to that point in itself?
It's a very relevant question in that there certainly are some changes proposed in the long run for the mining tax regime on the cards. Here I'm referring specifically to the Davis Tax Committee that provided their second and final report on hard rock mining in December 2016 already to the Minister of Finance, in which the Davis Tax Committee were tasked to have a re-look at the mining tax regime as we know it, and whether it is still relevant, whether it still serves the purpose for that it was intended for from the beginning. And essentially there were some significant changes proposed by the Davis Tax Committee, some of which National Treasury have already implemented, but on a high level, one of the big changes proposed is really that the Davis Tax Committee cautions that to get investors to invest in a particular industry like mining in this case, tax policy, which makes it attractive for those investors, is one thing. But we must be very careful to not overplay the role that favorable tax policy plays. And the Davis Tax Committee appears to be of the view that often we put too much emphasis on tax incentives, where other macro factors such as policy certainty, making it easier, reducing red tape, etc., for an entrepreneur to develop a mine are arguably far more important than just the tax policy. So with that caveat in mind from the Davis Tax Committee, and considering a principle of neutrality where it is preferable for taxpayers, like you want all your children to be loved equally, essentially, to make sure that all your taxpayers are in principle loved equally, the Davis Tax Committee has proposed that, we rather fix the very important things like ensuring there's policy certainty, reducing red tape, etc., and that we essentially, in a transitional, step-by-step manner, abolish the mining tax regime as we know it, and align it with the manufacturing normal tax principles, so that a mining company going forward in future, this is the proposal from the Davis Tax Committee, will be treated equally with, for example, a manufacturer. Now, you can imagine there will be a lot of transitional aspects to that. You've been treated in one way, and you've got certain balances of unredeemed capital expenditure under the mining tax regime that you've not benefited from. So, how that will work, and I don't think this is the right time to go into too many technicalities in that regard. But that is a big change that is being proposed on a macro high level by the Davis Tax Committee, amongst other changes that they have proposed. But to your question on how miners and contract miners have been receiving this special treatment to date, well, I think any child that gets more sweets than the rest, is quite happy to get the extra sweets. So we certainly, there's certain frustrations, etc. The law is not perfect as it is, but yes, generally taxpayers are, of course, very happy to get this benefit of being able to deduct the capital allowance in full up front to the extent that you have mining income. And certainly there's a lot of interaction between industry and National Treasury, recommendations made by tax advisory firms on behalf of our clients like Renmere in this regard. It would need to be carefully navigated if it were to be implemented, that we are going to move away from this special mining class privilege. I can't really comment on how soon or how far this is away. Like I've mentioned, certain of the proposals have already been implemented. But I think mining is such a key industry in South Africa. I know the contribution that mining has been making to GDP has unfortunately shrinked over the last 120 years that the mining industry has been around in South Africa. And that is unfortunate. However, mining still plays a significant role in job creation, as well as in foreign currency creation for South Africa. And yeah, so in that regard, I believe any dramatic amendments being proposed to the Income Tax Act as time develops will be done in a sensitive fashion. And there should be ample opportunity for industry to provide comment. And in that regard, National Treasury has been a privilege to work with.